Hi, this is Steve Walvik again, and I want to welcome you to my series on California family law. So again, the purpose of these slides is just to give you a very general overview. The area is much more complex, but I wanted to take some of the mystery out of things and give you an overview of the proceedings, how a case moves from start to finish, and the legal issues involved. So let's talk about the initial pleadings. For married couples wanting to divorce, they would file a petition for dissolution. For unmarried couples with children, they would file a petition to establish parental relationship, commonly known as a paternity action. Now, when the initial pleadings are filed with the court, certain restraining orders go into effect. You can't sell, transfer, or give away property in a divorce case. You can't cancel health insurance or auto insurance, and you can't remove the children from the jurisdiction that you live in. Now, those documents have to be served on the other side. So you can do that by hiring a process server, or in some instances, attorneys like to start off a case by mailing service to see if the case can start that way, which is a little less confrontational. The other side will have 30 days to file a response to the petition. Now, once all that's done in a divorce case, there's preliminary disclosures that you have to serve on each other. The court wants to make sure that you're not hiding assets and everyone knows what everyone else owns. So couples have to file a schedule of assets and debts, which list all your property and all your debt. You also have to file an income and expense declaration saying how much you earn, what your expenses are. For paternity cases, you would only file the income and expense declaration. And of course, as we spoke about, once service is done, the other side has 30 days to file a response. After the initial pleadings, and even before a response is filed, either side can file a request for temporary order. Now, these temporary orders deal with a wide range of subjects, including child custody and visitation, child or spousal support. In situations where the couple's living together and there's been issues between them, one party can even ask for exclusive use of the residence and ask that the court orders the other party to leave the residence. In situations where one party is working and the other party isn't, you can even ask the court to order initial attorney fees so that the party that's not working will have the funds to be able to hire an attorney. And also, in cases of domestic violence, you can ask the court for restraining orders. These temporary orders are really useful. They start setting guidelines for the couple to act and know what their rights and limitations are while the case has just started before the case is finalized. All right, let's talk now about general case issues involved in either a divorce case or a paternity case. So in a divorce case, one of the things that we look at are property issues. We have to divide the community property assets and the community property debt. So the first thing we're going to want to look at is what property was owned prior to marriage, what property was acquired during the marriage, what property was acquired after the marriage. Was any income from the marriage used to pay separate property? Was any income after separation used to pay community debts, and so forth? Property issues can be very complex depending on the amount of property the couple owns. Debts also have to be divided, and it doesn't matter if the debt's in one spouse's name or the other, as long as it was used during the marriage for the benefit of the community. In either a divorce case or a paternity case, we have to deal with issues regarding the children. So there's custody issues and visitation issues. Now, under custody, most parents will share joint legal custody. That means each parent will have an equal say in the health, education, and welfare of that child. If that child can get a passport, driver's license, issues like that. Only in rare exceptions does one parent get full legal custody over the other. Visitation is really important. When are the parents going to see and spend time with their children? What will the schedule be? Alternating weekends, 50-50? When will the drop-off time be? When will the pickup time be? Who will be doing the driving? What about holidays? What about school vacations? So all of that gets worked out under issues with children. Under support issues, if it's a divorce case, we can have issues regarding child support and spousal support. In a paternity case, it would just be child support. So let's talk just about child support for a moment. Child support is based on a computer program in California called a DissoMaster. And what the program will look at is the gross earnings of both parties and the percentage of time each spends with the child. This can be complicated when one spouse either just recently left a job and is not working and their income has to be imputed. Maybe they never worked and now it's time that they have to start working. Maybe they work under the table with cash and we have to prove what that income number really is. Spousal support is only in a divorce case, and it's to help parties stay in the lifestyle that they enjoyed during the time of marriage. So if the couple lived in a nice home and now one spouse lives in an apartment, one-bedroom apartment, they may be able to get spousal support. Spousal support temporarily is based also off a DissoMaster formula. Final spousal support is based off several factors in the California Family Law Code. Finally, there's other issues that could happen in either case. Restraining orders for domestic violence, which seems to be a very hot topic these days. Unfortunately, it's widespread in our community. And equally unfortunate, some parties claim domestic violence when no domestic violence ever took place just to gain an unfair advantage over the other party. In restraining order cases, paperwork is filled out and presented to the court with a declaration under oath as to what took place. And if a judge feels that a temporary restraining order has to be issued, the judge will issue that temporary restraining order. And that could affect where a person lives and if and when they're ever going to see their children. A trial will be set for the final restraining order, where evidence is put on, and usually it's a very short period of time in between a temporary and final restraining order because of the serious impact on the freedom of movement and on the ability to see the children that a restraining order can have. Attorney fees are also an issue sometimes at the end of a case. Again, if one party has a disadvantage on income versus the other, or if one party is just obstinate and not working together with the other side on a settlement, attorney fees may become an issue. So let's assume that we worked through the initial pleadings, a response was filed, there's been some temporary orders issued, all that's been dealt with, and now we're looking at, so now what? How do we end this case? Well, a case ends either one or two ways. Actually, it could actually end one or three ways. Let's talk about the two that are on the slide, and we'll talk about the third also. So, a lot of times, family law cases end with a written settlement agreement. The parties will agree to all the case issues. They'll lay it out in like a contract form. They'll sign it, file it with the court. The court will eventually enter it, and they're divorced, and they have an agreement which to live by moving forward as to their rights and obligations from the marriage. If parties cannot agree, and they're just butting heads, they can't agree on what day it is or what time of day it is, then the case is set for a trial. And just like any trial that one would see on TV, kind of like that in a family law court, except there's no jury, it's in front of a judge only, you present your evidence, and the judge is going to make a final ruling on all those case issues. Now, there is a third way a case can conclude, and the third way is reconciliation. The parties agree to get back together again. I've seen that happen a handful of times. It's more the exception than the rule, unfortunately, but it is a third way to possibly conclude a case that a case gets dismissed. Well, I want to thank you for taking the time to view these slides, and I want to stress these slides were such a simplistic general overview. There is so much more than meets the eye in these slides, and a lot more work and detail that has to be done to get a case from point A to point B. Because of the complexity of a family law case and the impact on a person's life moving forward, the worst thing you can do is represent yourself. A person needs a quality attorney to guide them through the process. I mean, after all, you wouldn't do surgery on yourself, would you? So why would you go into a family law court arguing over retirement assets, children, support issues, and all those things without the benefit of an attorney? My law office has been representing individuals throughout the state of California in family law matters for the last 27 years. I pride myself on taking the time to personalize each case because each case is different and each client deserves that individual attention. Our hourly rates are very reasonable in the community, and we do something that no other attorney or no other law firm that I'm aware of does. We never charge for telephone time or email communications with our clients. Most every attorney bills for every minute they work on a file, and that would include talking to the client. We never do. I want to know what's going on in my clients' lives. I want to know what's happening with them. I want them to take the time to tell me. And if I ask them how they're doing, the last thing I want them to do is look at their watch and say, Steve really doesn't care. That's 0.25 on his billing sheet. My practice is limited to the state of California. These slides were a general overview of the California family law system. We have offices throughout the state of California. I take cases in the Sacramento area, Oakland, San Jose, Bakersfield, Riverside, Los Angeles, and of course where my main office is in the San Fernando Valley. To schedule a free no obligation consultation with my office, you can visit me on the web, the link's on this slide, or feel free to call me at our toll-free number. Here's what you're going to find. When you call the office, you're not going to speak to a secretary or a paralegal. You're going to speak to me directly. I may not be able to give you real specific and finite details about your particular case, but I can at least give you some thoughts based on you filling out a worksheet that's on our website. So if you're interested in that free consultation, visit the website and go to the worksheet tab. Fill out the family law worksheet, and then on our pop-up telephone scheduler, go in there and set an appointment to call me. That appointment gives you an uninterrupted 30 minutes of time to talk to me about the questionnaire that you filled out and for me to ask you questions. It's a time where you know I'm not working on another file or taking another call. It's also a time that you know that we're going to speak, so you'll be available and I'll be available. And I look forward to talking to you soon. Thank you again. Take care.